Hello, everybody. Welcome to my presentation, Expert Witness, what every engineer needs to know, and not just any engineers, but any professional person that's can possibly be called upon to be an expert witness. A lot of people say, you know, I'm not going to ever be an expert witness, but think of this. If you're working for an entity and that entity gets sued and you were working on that project that they're suing about, you may be called upon to be an expert witness, whether you like it or not. So it's a good thing that you're in this presentation because you may be drafted in doing such an honor of being an expert witness. Again, my name is David Williams. My information is right there. I live in Commerce City, Colorado, which is a suburb of Denver. In fact, I'm only about 5–10 minutes away from the airport there. My email is there if you have any questions. I also urge you to put into the chat session any questions that you have, and if there's a particular point that you'd like to point out to, notice on the lower right is the slide number, so you can reference that so I know exactly what you're referring to. However, if later on in the presentation or after we finish the presentation that you have a question about, there's my email right there, and I generally answer emails within an hour or so when I can actually see it. Okay, again, I'm David Williams. I have a doctorate in civil engineering, and I'm a registered professional engineer in about 8 to 9 states, professional hydrologist, certified floodplain manager, and certified professional erosion sediment control, diplomat of water resource engineer, which is put out by the American Society of Civil Engineers. I'm a fellow of the Environmental Water Resources Institute, which is a division of the American Society of Civil Engineers, or ASC, and I'm also a fellow of ASC. Now, I put these out there in front of you because it's an important part of being an expert witness, because a lot of times being an expert witness is a matter of, okay, I got better credentials than you. And so I reserve these credentials as I need them. I don't put them all out in front of the jury or the lawyers, because what it is that it can be kind of cumbersome and some of them are not applicable, but I have them handy. So let's say that it's litigation is related to a floodplain management issue, and it involves the accurate evaluation of the peak discharge. That's when I pull out something like a PH, professional hydrologist. That says I am registered. Not only do I think I'm great, but somebody else tells me that I'm great too, and they conferred me a professional hydrology certification. And then if you're interested in things such as FEMA regulations regarding floodplains, well, I have a certified floodplain management certification. And so I've been recognized by my peers in the appropriate organization that I'm very good at this floodplain management stuff, even though I'm not a floodplain manager, but I know all the things that a floodplain manager should know. So that's why I'm putting all these out in front of you, because if you're going to be an expert witness as a profession, or even a side profession, and a side profession is what I use it for, you may need to have some of those certifications, because again, that puts you up and over the other experts that says, well, I'm an expert in this. Well, I'm an expert in this. He says, well, I'm not an expert in this, but other people say I am. And then the other person says, oh, I'm sorry, I don't have that certification. All right, so I'm the president of my own little company. It's a one-man wrecking firm. It has 4 columns, but I just recently moved to Commerce City. There's my email, and there's my phone number. So a little bit of introduction about me. I've got a bachelor's and master's in civil engineering, which is part of our middle, in Davis, California, University of California, Davis, and my PhD in civil engineering, in the civil engineering department, which is on the river mechanics. And I got that at Colorado State University, which is only about an hour north of where I live. And my job history, or work history, I worked as an airborne combat engineer, 7th Special Forces, also known as the Green Berets. And that just shows you how old I am, because that was the Vietnam era. The U.S. Army Corps of Engineers as a civilian. I was at the Hydrologic Engineering Center, Nashville and Baltimore districts, and I was at the Engineering Research and Development Center, which is formerly the Waterways Experiment Station over West. And I'm also a past president, a co-founder of West Consultants, and which I sold about 10–15 years ago after nurturing it up to about 30 engineers and scientists. I also taught some various engineering courses at UC Davis, San Diego State University, and Colorado State. And for those in the private sector, I'm the National Director for Water Resources at PPS&J, which got bought out by Atkins, and also HDR. Now, hear this. This is not legal advice. It's a lecture on general principles of being an expert witness. So if you do have some legal issues and you need some legal advice, just make sure you see a license that's a lawyer that's licensed in your jurisdiction. So again, this is not legal advice. It's just guidelines I'm giving you and just give you an introduction on the things that are related to being an expert witness. So I'm proud to announce that the first expert witness in court was a water resources engineer, because I am a water resources engineer, so I have pride in this. That's why I bring this out. The earliest known use of an expert witness in English law was in 1782. The court, before the argument was from between lawyers, and each side attorneys would argue the case, and then the judge would decide or the jury decide. However, when things are kind of complicated and the attorneys could not adequately convey the complexities of the situation of the lawsuit, they had an expert witness, and it was related to a hearing of litigation related to the silting up of Wells Harbor in Norfolk, Virginia. And so one of the lawyers said, okay, I can't talk confidently about this topic, but I got an engineer here that can explain the situation, the physics of it all, to the person, which is you're citing, or to the jury. And so the jury, not the jury, but the court accepted that evidence from the leading engineer, which is John Smeaton. So this decision, this first decision in 1782, started the concept of accepting the testimony of an expert to do expert witness stuff. So this decision, again, by the court to accept Smeaton's evidence is widely cited as the root of modern rules on expert advice or evidence. So it's always, one of the first things I'm always asked when I'm retained as an expert witness is, what's my history in being an expert testimony? And this is as of January 2018 that I did this. And since that time, I've been involved in about 5 or 6 extras, but I didn't bother to update this. But one of the things they ask is, all right, are you for the defense or are you for the plaintiff? Are you for private practice or are you for public practice? Are you for shallow pockets or are you for deep pockets? So those are the things that the lawyer asked me, because those will be, if it's cited in one way or the other side will get that information and use that against you. So I'm going to show you what I present to the lawyers when they ask something like this. All right, well, for instance, went to trial. It was about only 3 cases. This is for a private client for the plaintiff, and this one is for private client for the plaintiff, and this was another one that's for private client and defendant. So you can see I got 2 plaintiffs and a defendant that actually went to trial. So then it went to arbitration. That means that the both sides agreed to go to a arbiter, which usually a retired judge, and maybe a retired prosecutor or a defendant that has some good years of experience in the process. And they go in front of it, and sometimes it's binding and sometimes it's non-binding, binding or non-binding case. And so of those that I have had, 4 cases went to arbitration, which then a decision is made. And it's not as formal as a court condition. So here's one. This is for the plaintiff. It's a public Kern County public for the plaintiff, and plaintiff. And so all my courses that went to arbitration were for the plaintiff. That we are complaining. The plaintiff is we're complaining to somebody, to the court about somebody, and want to get money or some sort of a compensation from them. So this is a little bit heavy in terms of the arbitration part, in terms of plaintiff. So just to let you know that of the 40-something cases I've been involved in, I've been lucky to be a winner in every one of them. But sometimes I'm not sure how much I won in terms of my side may have gotten the money or the award that they wanted, but maybe not 100%. Maybe only 50% or 75%. But those things are usually privy to only the people that are involved in the case, that is the plaintiff and the defendant. So I never know, but usually if it didn't go well on my side, the lawyers would tell you, and so that's never happened. So I like to think I have 100%, batting average here. All right, so the other side withdrew. There were 5 cases at me after I put in my expert report, which I'll be talking about it later on and what goes into it. The other side withdrew, and so there were 5 cases. There's the defendant, which is not, alarming that I want to defend on all of them, and because the other side withdrew based upon my testimony in deposition and my report. And so what essentially this is telling me is that I did a sufficiently good job such that when my report came out to them, and the other side looked at it and says, my expert, take a look at this. Is David right or not? And they'll say, okay, it looks like he's got a case or whatever, or he's got a slim chance of having any success in this. So then that's what they would withdraw. And so it's not unusual that you see defendant on every one of these 5 cases that the other side withdraw. And then there's settled out of court. There was 13 as of the beginning of 1998, which is about a year ago. And so this gives you an idea of plaintiff, defendant, plaintiff, defendant, plaintiff, defendant, plaintiff, defendant, plaintiff, plaintiff. So you can see it's a good mix of various, defendant versus the plaintiff. And so, and also as an expert witness, you have things. You do things such as what's called non-judicial expert testimony / opinion. And that's still part of your expert witness experience that you'll find. And I had 5 of those. And what they're saying is that it may be a fishing trip that the lawyers are involved in. What they do is they have a situation that they think they may or may not have a lawsuit involved in it. And so what they'll do is they'll hire you to help them determine if there is a basis for a lawsuit. And so that's why I call that non-judicial expert testimony and opinion. It may be that later on, you will go into a judicial situation, but at the point that you're hired, it's a non-judicial. That means they're just doing a fishing test here. So this is for this is a Superfund site that I worked on. Licensing, for relicensing, restoration, pipeline purchase. So every one of these lawyers or attorneys that represented these entities were going to sue, but want to make sure that they had a good basis so they can tell their client that you do have a case. And so I was involved in those 5 cases. So the summary of experiences as of the beginning of 2018, went to trial, 2 plaintiffs, 1 defendant, went to arbitration, 4 plaintiffs, other side withdrew, 5 defendants, settled out of court, 7 plaintiffs, 6 defendants, summary not counting forensic engineering only, that's the previous slide, there was 13 plaintiffs and 12 defendants. Now that, to me, is is a good balance. So I present this information to the attorneys, which then they say, okay, they can't say they were slanted toward a plaintiff or slanted toward defendants because that's where the money goes. And so remember, the attorneys will try every trick in the trade they can find to try to discredit you. And one of them is your credentials, and the other one is your what side did you go on each of the cases. If you are on one side and you only look over the people that have money. So out of the 3 out of the 25 at that time, or about 13% actually went to trial. The average is about 10, so I was not too far off from the average. But only 1 out of 10 lawsuits actually go to trial. The rest of them go through either arbitration or other side, one side drops, or there's mediation, another part, and then also they just drop out and just say, let's lick our wounds, everyone pay their own expenses. So here's what I'm going to call the closest encounters of the first kind, which is an inquiry. And note that some of this information comes from SEAK, which is an expert witness resource that you can look for. I am registered with SEAK, or SEAK if you want to say it that way, for as an expert witness, so people can look under under their website and search for maybe a certain discipline, maybe hydrology. And so they would say hydrology, and they would specify what state, and then I would come up with a bunch of other people saying that these are experts, and then they read our resume. So one of the first thing I ask for, or I'm aware of, is under the inquiry is watch out for preemptive strikes. Attorneys may contact you and try to get you on a retainer to take you out of the game. So what they do is they may have an expert witness already in your area. And so what they say is, look, who can damage you? Who is a very credible witness that can oppose you and go toe-to-toe with you? And then they say, well, it may be David Williams was the person that that could possibly do me damage or is have credentials equal to mine. And so then what they'll do is they hope that you haven't been contacted by the other side, and they say, hey, would you like to be a consultant? And we'll fly you out or what have you. So what you do is, if you accept it, you're out of the game because now you're committed and you can never be used against their experts. So you should ask who else is on their team, and they better be honest about it, and if they will be covering the same expertise that you would be. And so that gives you an idea that they're fishing, and they may be trying to get you out of the ballgame. So get that kind of information. And to help prevent that kind of preventive strikes, I usually ask for about $5,000 retainer before I even get on their case. That means you will, before I touch anything, do anything, you will provide me $5,000 in cash, or not by check, and then I will, once I deposit, then I will start on your stuff. So if you're trying to play that game of trying to get me out of the game, at a minimum, it's going to cost you $5,000. And what I tell them is that it's a non-refundable. And so what happens is that if I actually work on it, I keep track of my hours and charge it against that $5,000. And once I exceed that $5,000, then I send them an invoice for any amount over that $5,000. So that's how that works. And I always ask for a retainer. And depending upon your experience and your expertise, I've seen it range from retainer from about $2,000 to $5,000, and actually seen some people at $10,000. But usually those are for like medical people that do malpractice. So get a brief case of the background. What kinds of cases is this? You should be asking the attorney, and who are the parties? Like, are you the plaintiff, or are you the defendant, and are you defending who? Further inquiries, where will the case be filed? This may be important because it might be in an area that you're not competent in terms of geological area. For instance, I do most of my work in Colorado, but Texas and California are very big clients of mine in terms of expert witness. But let's say they're asking for my expertise in the area of, let's say, Alaska. Well, Alaska, maybe I don't feel comfortable to do that. So that kind of information is very important on where is the case and will it be filed. So what are the deadlines you should be aware of? I've had to say that we need you to go out to the field and give me a report by next week because we're going to trial and be deposed. Well, I may have a tendency to decline that assignment because I may have a big project in front of me that I got to get done in that time frame. So what are the issues that you'll be asked to address? And this is also an indication if they're using to preempt you or not, because let's say it's a general area of hydrology and hydraulics, and the hydrology is a very small part of the analysis, and then I'm asked to do that part, and they got the other expert doing the hydraulics, which is maybe 90% of it. So that gives you an idea of, well, I'm going to be used here. So how much is a dispute? This gives you an idea of what's at stake, and I like to ask that because that gives me an idea of what the other side, that my side, that is my attorneys, are willing to spend on this. And so this gives them this gives you an idea of their expectations. And so I make it clear that if the war is only maybe $250,000, I doubt very much is they're going to want me to go in and do an analysis that may cost 25 or 10% of that award. So how many pages of documents will you be sent for your review? And the last case I did was they said, I'm going to send you 40,000 pages of documents to read. And then you compare that to what are your deadlines, and you got to be honest about them. on if you can make that, especially if you have other projects in mind that you have to work on. So, have the other experts been selected yet? And if so, who are they? Because you may know them, and that would help you determine if there's a conflict of interest. One case I had where the other side actually had hired my mentor when I was going through the engineering profession. They hired my mentor knowing that that would probably rattle me. Rattled me initially, but then I did find out that I had some solid footing on my side of the analysis. So you ask for the other side experts, and hopefully you know them and they get a good idea of if you have a credible defense against them. Will a report and/or deposition like to be requested? I ask that. That gives me an idea of the timing and the amount of money that they're going to spend. What has counsel's experience been with these types of cases? And that's very important because if the counsel has maybe done only, let's say, construction defects in engineering, and here I'm a hydraulic engineer, there's going to be a learning curve for that counsel, that attorney on my side. And so I got to make sure I allot extra time for that kind of activity. And where did you get my name? I asked them. That gives me an idea of how my marketing efforts are done. And I find out that over 50 to 75% of my work is by referral. That means people have used me before, or my colleagues have been asked for an expert witness and they refer them to me. And also, I do a lot of teaching. So if you Google my name, David T. Williams, about half the page will be me because I do a lot of teaching, both online and also in person for various entities. And so, and you would probably, if you Google my name, you start to see me under PDH source as teaching this course. So close encounters of the second time, possible acceptance sentence. CYA if you do. So questions you ask, if you say, okay, I will consider, after answering all those questions that I just showed in the previous slide, I will going to have some additional questions. Is, are you comfortable with the lead attorney? That means you probably have talked to that lead attorney, get a feel of their personality, and see if you can be comfortable with it, because you're going to maybe spend a lot of hours with that lead attorney in preparation for and during trial. Are the attorneys straightforward answering your questions? They may be hiding something that you may not be aware of, but so you just kind of evaluate their honesty in terms of if they're hung around some fairly straightforward questions and they don't give you a straightforward answer. That should be an alarm for you, because you're not fully accepted yet. It's a possible acceptance. Can you work with their other experts on their side? For instance, let's say you're doing hydrology and I'm doing hydraulics, and we have a little rivalry going, but we're different entities of water resources, so we can be experts for those areas. However, if I have many animosities or any type of conflict with them from earlier experience, I have to take that into consideration before I possibly accept. Can you keep emotion out of the case? You got to really be asking yourself questions on this, because one litigation was related that I worked for in St. Louis involved the drowning of the plaintiff, the family of the plaintiff, and so that can be an emotional situation, and so you got to understand that. Can you and ask yourselves honestly, can you handle that kind of emotion where there's going to be testimony about how someone died? Can you be objective about the case? And again, they'll ask about that. If you ever been on jury duty, they'll ask you, can you be objective about the case that's up? If they're hunting for, let's say, police abuse, then one of the things they'll ask is, well, do you have any close relatives that are police? And so they want to make sure that you're objective. And this is the same type of question. Can you be objective about the case? Can you objectively deal with the other side's experts? Right, this is versus the other experts on your side, but then can you objectively deal with the other side's experts? And this is related to that incident I told you about where my mentor was hired from the other side. So close encounters, still close encounters the second time we're doing possible contact. Some rules of thumb here. take the case even if you feel they're wrong or to blame. Why? Well, it could be that they are to blame, but maybe there's lots of blame to share. And so your side should not bear the brunt of the consequences of the entire damage, because there's other contributing factors that were happening. So you may be able to take that case, even though they're wrong, but they're not wrong to the extent that the other side has accused them of. If you see a possibility, you'll take the case, meet with the lawyers before committing, initially at your own expense. And why do you do that? Well, if it's initially at your own expense, no money is handed on to the other side. And so forth, there's no financial tie to that entity, so you can withdraw easily and then possibly be hired by the other side if you think that's an appropriate thing to do. So you obtain a retention, which is different from a retainer letter, with the specifics of things such as the statement of the case, fees, what's expected, etc. I have an example letter in the next slide. So update your resume also. For instance, are you current or past chair of the committee? I had one guy that was on the other side that knew me, and it was a former colleague of mine, and he pointed out that I was no longer in my resume. I was no longer committee chair of this SEAK committee. And so I thought that was kind of petty, but he had a point. I was past chair. And so what I did is that I made sure that all my resumes had a date on them. And so when they bring that up, I said I was president of that committee as of the date of that resume. And so you should always put the date of your resume on there. Take out all your embellishments. For instance, if you said that you were actually on this team that developed the software, don't put in that you developed the software. So those type of embellishments, any kind of embellishments at all, take them out. And it's also embellishments such as, okay, world famous hydraulic engineer. Well, don't put that. Nationally known hydraulic engineer or nationally known hydrologist. Those are embellishments. So just say something like well known, but don't do embellishments. Submit a short summary and a full resume to attorney to be as appropriate. I always give them a short summary, 1 to 3 page summary that they can pass on to the other side to show them who's on their side. And I also may present a full resume at the request of my attorney that they can pass on. But the reason I put in a short summary is that my long summary has detailed information about the projects I've worked on, and also I had about 150 references in my resume, and so in my full resume. So why are you handing them all the information so they can research you? Or just give them a short resume and have them go out and research things. And sometimes they will not find something that would find in your full resume. Here's that example retention letter that was given to me. This is by DeHulio Law Corporation in California, Glendale. So they put my addresses as when I lived in Fort Collins, a retention letter, and citing the case itself, me confirming that everything is per the request that you had, and then also would like your firm to determine if SoCal's belief is correct. As we discussed, SoCal agrees to initially pay a retainer. There's that $5,000 I told you that we would do, and then all the other information that I've asked for. And so that's all right here. This is 3-4 years ago. So this is an example of a retention letter that I specifically asked. In fact, I asked about 10 items to be put into the retention letter that I use standard, saying that for you to hire me, I need, please provide this kind of information by email. I send it by email, and then they'll write me a retention letter. So there's close and comedy of the third kind. Everything's been done. We're going to do discovery in terms of up to this point, better discovery. So discovery is a pre-trial phase in which each party through civil procedures can request documents and other evidence from the other parties. So this is they're trying to discover the information on the other side. You should work with the attorney to help in this process, because you're going to be asked under discovery and you will be asked under discovery. So what you need to do is work with the attorney and says, okay, we're going to ask this other side, specific information related to my area of expertise that I've been hired for. So what I want to do is, okay, what you need to do is see if they have an engineering report. Did they file a certain form to FEMA like they were required to? Those type of things, you help them specifically because your attorney is not an expert in this field and doesn't know what kind of question, what kind of material to ask for. And you, as an expert, should know this type of things. And then also, they'll ask your attorney to provide certain information. Then you have to work with your own attorney and say, okay, I got this, and this. I think it's pertinent to the case, and you provide it to the attorney. So also under discovery is are all the emails that go back and forth between the parties. Just let you know that your emails and other correspondence by mail or whatever, even your preliminary opinions, personal comments, strategies, etc., are not written down. Make sure you're not written down. And so, but your emails are discoverable. And so I try to use my memory as much as possible when I do preliminary opinions and personal comments and things of this sort that I talk to. And so a lot of the time I don't email my attorney, I call them up and talk to them. So so to help in this endeavor, all your emails, not only that you receive, but also that you send out to me. So here's what I do. I always answer emails. I have a folder that a project folder that I put my emails, and then also when I send anything out, I CC myself. I CC myself a blank copy. So when it goes out, I get a copy of that blank, one that a blank copy, not a blank copy, but a blind copy, not a blank one, a blind copy. And so then it goes back to me what I sent, and I put that in the same folder. So I have my inbox and outbox of those emails. And then what I do is when they're requested for that, I create a PST file for that, Outlook PST file for that folder, and then I send that off to the appropriate people. So your publications and presentations are discoverable, so make sure that they are not a contradiction to your opinions in the case. Because I'll show you, they'll look for those publications and scour them, and not only just the lawyers, but their experts, and see if there's any contradictions to what you say there. Excuse me. So let's start as part of that discovery process and the contact of the third kind. There's things what's called affidavits. Our affidavits are written declarations made under oath, usually certified by a notary public or any public official authorized by law to administer oaths and affirmations. So what you do is you can write your affidavit, and then you have to go to a notary, let's say, and they put their signal on it, and then you scan it or send a copy to whoever is requesting that information. An affidavit is based upon either the personal knowledge of the affiant, that's the person, that's you if you're writing the affidavit, or his or her information and belief. So you normally would be asked to write an affidavit stating your opinions on the case and the reasons for your opinion, but it's usually narrow in focus. So usually an affidavit is only maybe maximum about 5 pages. And what you're doing is, okay, I believe this, I believe that. So you don't have to have a full backing of your opinions, but you're going to express your opinions. So usually in connection to a motion, that is for summary judgment, suspend deposition, or a trial date. And so what your attorney will be the one will be asking you to write an affidavit in support of his case, his or her case, and that's and it's just a bullet item, just saying I am this, I believe this, this is the reason, this is what happened, my belief is this, and then in another document, which is the report, that's when you back up your assertions on that. But the affidavit is fairly short. So affidavit differs from the regular report because affidavit is more assertive. This is provides arguments of why. This is and like I say, it's maybe the accusation or the findings are maybe 2 sentences. So maybe that I think that they are responsible for flooding of this particular resident because of negligence on their side in operating the upstream reservoir. So maybe something of that sort. And then again, when you do your regular report, that's when you talk in detail about what did they do this operation of this reservoir that caused this damage. So a court cannot force an expert witness to provide an affidavit, but it's very helpful. In fact, about 95% of the time I'm asked to write an affidavit because that's the basis of their lawsuit. So they may have an amended complaint, let's say, or amended defense filing, which then they say, for let's say the defense says, okay, we do not believe that that we are the reason that this thing happened. And we retained, let's say, Dr. Williams and attached his affidavit asserting that we are not at fault for whatever happened. So there's no standard form or format or language to be used in an affidavit as long as the facts contained or stated directly and definitively. So unnecessary language or legal arguments should not appear because this is an expert testimony. You're not the lawyer. And so don't do unnecessary flamboyant language. So make sure to put draft on all preliminary affidavits, because then if the other side sees that maybe you changed your mind about something, you say, well, yeah, well, it wasn't my final determination, that was my preliminary determination, and that's why it was put draft. Your attorney will look at your draft and make suggestions on improvements, and they also formalize it for submittal. And so you write it as probably a fairly assertive document, of which then they reformat that and make it into a legal document for submittal. So that's where I say they'll formalize the submittal. So don't change your statements if you feel they're correct, even though your attorney may want you to change or bend them. So don't exaggerate your assertions, because then it'll bite you in the butt when your affidavit is compared against your report. Here's an affidavit. This is a buddy of mine that I was actually in the same case. He was on the other side, and so this is a full supplemental affidavit of Rick Van Ruben. So it was actually in the state of Missouri, but he did the deposition and not deposition, but he wrote the affidavit and had it signed in county of Sonoma, which is where he was close to. So he asserts what he is. Gives a little bit about what he does, and a little bit background on education, and it's fairly precise when it goes on down to there. So maybe about 10 bullet items that he had in this affidavit. So other documents, an engineering report can be produced. This document is pretty wide ranging because now it's almost a textbook, because you're going to be explaining why you made those assertions in your affidavit. So the expert report defines the issues and points out the shortcomings of the other side's argument. I'll show you the slide for example. Declaration can be made that is similar to an affidavit, and so usually the declaration is submitted to your attorney, and they submit it formally to the course. And I'll show you a slide for that example. So sometimes a declaration is made in reference to a call for summary judgment. Your side says, the other side guys, it's so weak. We're going to ask the court to just throw it out. And so then he says, well, why should we throw it out? Well, David, could you write a declaration that's similar to the affidavit, but a declaration supporting my request to throw this case out, and that's under summary judgment. And so then I'll write a declaration that's a little bit different from an affidavit. All right, amendments to other documents you produce can be submitted. So just because you may submit something on it, it's not chiseled in stone. The statements are chiseled in stone, but maybe your opinions are not chiseled in stone, because you can have an amendment saying that, I got some additional information, details from the field or something of this sort that made me change my mind and think about this, and I'd like to change it. So you can make an amendment to it. And so that's why I put in all my reports, at the end of all my reports, saying that this report was done under the care of a normal engineering expertise and was expected of an engineering report, and that if any additional information comes to it, I reserve the right to change my opinions. So that's under that amendments to other documents. Here's an example of what I did. This is where I was on the side that sued the Corps of Engineers and all suing the things such as people such as the Corps of Engineers, Fish and Wildlife, or any federal entity. It's not handled by that entity, it's handled by the DOJ, the Department of Justice. And so it's so everything like that is related to the United States of America. So if you're suing any federal entity, it's against the United States of America. But in parentheses, I'd say this is the case, which is the Corps of Engineers, Omaha District. And here's me putting my credentials. I introduced myself right here, and then the background of it. So this is related to flooding on the Missouri River. And I was defending HGL farms that got flooded out due to the actions of the Corps of Engineers. And not very often that you actually win a judgment against the Corps of Engineers. So a little bit about the background, so I provide that information. And then at the end, I put that little disclaimer saying I reserve the right to change my opinions and so forth. So here's a declaration for another case I had. This is up in the state of Washington, King County. And I wrote the document, and then you can see it looks more like a legal document. So my attorney grabs all my information and puts it in there, which then I print it out and then I sign it. So here's a pretty quick. This is for a request for summary judgment, if I recall. So it says, it gives a little bit about me right here. And retaining, so you can see it's pretty precise. And this is like, I gave all my, this I think was like a 4-page document that I said, okay, you got to throw this out because this is wrong. And the assertion of the other side is wrong. I think this is what caused it, and so forth. So that's about 4 or 5 pages right there. That's the declaration. And you can make a presentation like this one. This is what's called Sarkey versus City of Reno, and I was representing the City of Reno. This is when I was at PBS&J a little over 10 years ago. And so what I did is I made a presentation to the judge, and the judge had thought that the plaintiff's attorney was milking his clients for money and trying to milk them for lost cause. And so what he did, the judge, says, okay, let's get both sides here and give a presentation, not in front of just me, the judge, but also the plaintiff and the defendants. And so the neighborhood that was suing the city was present, some of the people they're representing their community. And so they heard both sides of it. And then the judge told the lawyer and then told the plaintiff, say that now, do you want to still continue on with this lawsuit? Well, after that presentation, they withdrew the lawsuit. But as again, you have to go as if you're going into a trial and have all your ducks in a row there to do this. And so this is part of a PowerPoint that I made in defense of the City of Reno. So general comments on discovery, affidavits, and other reports. So talk to or meet with the other experts on your side. Make sure that, especially if you have some slightly overlapping expertise, that you need to be hand in hand with this so you can't have any discrepancies between the testimony of the 2 experts or 3 experts. Get a copy of everything that your client and the other experts on your side present under discovery that touches your area of expertise. Remember that discovery got all the other people's information, sometimes their opinions, their reports, their affidavits, anything of that sort. You want to have access to it and read that. There are overlapping in expertise. Decide who's the most competent on the subject to write in their affidavit. So let's say me as a hydraulic engineer and there's a hydrologist on our side. There's an overlap between hydrology and hydraulics. And so we got to decide, okay, when there's overlap, who's going to take it? Who's got the best expertise and who wants to take it on? And so they write on that portion in their affidavit or any type of report on that portion that they have been held responsible for. And then you look at each other's reports and say, okay, this meshes very well with the other report. So that's, again, review each side's draft of affidavit for consistency. Make sure that your attorney understands the science and engineering basis of your testimony before you present it. So, that's part of that, maybe possibly increase in your costs for that, because you may have to sit there and educate your attorney on the science of what's being said. And so, so what you do is you write down your affidavit or your report. You go in front of your attorney face to face, or maybe through the internet, and just say, okay, now here's what we're talking about here. And so sometimes I urge them to take some webinars on maybe the subject, like the basics of hydrology, and an attorney will actually do that sometimes. So some comments for up to trial or arbitration. Don't talk about the case to your to colleagues. Tell your staff that working on the case not to talk about it to their colleagues either. If you have any staff, just say that I'm working on the case, and don't name the case. Don't name the progress or anything of that sort. Keep all information in one reasonably secure place. Be careful with emails, that is double check forwarding, CCs, etc. to the right people. I'm sure that you guys have had emails that weren't meant for you, and you kind of laugh it off, but it can be very serious if it goes to the wrong people related to some litigation. Try to keep everything in your head and don't write down notes if you can. All is discoverable. I have a story about this one city official that wrote things on the margin on the report saying that this part is BS, or this part is a good point. And under discovery, we got those hand scribblings on him, and we used those hand scribblings against him because later on he changed his mind about some of the aspects of what he wrote down in the margins of the report. So, close encounters of the fourth kind: contact with the other side. Deposition, not settlement deposition, is expert witness testimony given under oath and recorded by a court reporter for use in the court at a later date. All right. The opposing attorney questions you in real time. Now, you can do this in face-to-face, right, at a mutually agreed location or by a WebEx. I've only done one deposition by web, by internet, and by web, and the rest of them are all by location. And they can be fairly crafty in where they want them, because usually there's three places that they allow you to do this deposition, or they want you to do this deposition. One is the opposing attorney, and the other is the defending attorney, and then the other may be the location that's mutually agreeable by you. So for once, I did a litigation that was in Albuquerque, New Mexico, and the people that were involved, that is the attorneys, were one was located in let's see, I forget, another state, and one was another state. So there were three different states in terms of the location of the case itself, locations of the lawyer, and where I was. And so I could drive 30 minutes to Denver, and so one side could save travel costs if I drove, and also like lodging and per diem if I drove to Denver, which is only 30 miles away from where I was. And so they decided to do there, and I think there was some alternative motives, because this is winter, and I think the guy came, asked for doing a dinner so he could drive up and go skiing. But that's only speculation. So the person being deposed or questioned is the deponent. So you'll be called the deponent if you're doing the deposition. All right, so again, this is where both sides of the attorneys, both sides of attorneys are going to be there. And I've had it where the opposing attorney may have a deputy attorney to help with that person. So I've had it where the most on one side was 3 attorneys sitting there, because that's not just one attorney representing the case. It may be that if you see a lot of them, says the plaintiff et al. Or the defendant et al. Et al. Means all these other people. So there may be multiple entities being sued or suing. And so those different entities may provide their own attorneys to sit on the deposition. So you will be outnumbered by the attorneys. So copies. Attorneys from all sides can be in attendance, and they will ask questions. Copies of the deposition are made available to everyone after you have made corrections to the transcripts. Now, a lot of people don't realize this, but once you make a deposition, you will be, within about 30 days, you will be given a transcript of a draft transcript. Right. So if you are asked to then go through, you have a sheet of paper on the side that may have you put your comments in there. And so what you do is say, oh, okay, well, I said it was 0.04, should have been 0.4. Okay, that's fine. So you say, all right, in my deposition, I said 0.4, should have been 0.04, vice versa. So I write on this piece of paper they provide you, saying in line so-and-so, it says this, it should say this. Okay, people make mistakes, or maybe you did make the mistake. Maybe it was a transcription mistake by the transcriber. And so make sure you go over there and make sure that you have put in the proper information and also that you didn't make any mistakes that might change the opinion that is expressed. Right? So you have usually about 30 days to make this change, and then send it into the transcriber, which then they'll make the changes. So don't make wholesale changes like that. May be changing the whole concept of what you're trying to present. Don't do that. But there's just for little mistakes, like we discussed. So continuing on deposition, the other side's experts may be present and feed questions to their attorney. Sometimes they can be dramatic. All right. So what we're saying is that if, let's say my side is opposing their experts, I am allowed to be there right beside the attorney on my side of the table and direct questions to the person, but I cannot directly ask questions. What I can do is during the process, I'll maybe write something down on a piece of paper and hand it over to them. And I've had attorneys where they became dramatic. They'll look at my notes and they'll go, oh, get that look of amazement, you know. And what they're doing is gaining the other expert, because they say, oh my gosh, they got something good on me. So they can be very dramatic, and vice versa. I've had it done happened to me, where I've seen it where a statement was made, and then a document was a note was handed to them, and then two of the lawyers look at it and raise their hands back there and went back in their chair like they got blown away, and I just started laughing. So there are two types of objections for your lawyer to the questions posed to you. One is called privilege. They are asking questions that are protected under law. And the other is object to the form of the question asked. Note that this generally means your attorney is wanting you to be careful, all right? So what they'll do, it throws you off sometimes. So the other side will be asking you a question, and then your attorney says, object to the form of the question asked. And then they'll look at you and says, then you may answer. I said, well, you objected, but you're going to tell me to go ahead and answer. Well, what it is on the note, because this objection to the form of the question is put into the transcripts of your deposition. And so when so if you mumble or you stumble on the question or get it completely wrong, and the other side uses that testimony in court, what your side will say, well, but you got to remember, just in front of where Dr. Williams answered that, I objected to the form of the question. And the reason I objected to the form of the question is that it was very confusing, double negatives and such, that Dr. Williams did not fully understand the question, and therefore he gave a wrong answer. And so that gives them leeway to be able to change your opinion during trial. So let's go back to privilege. What is privilege? Well, usually the privilege is between the client and the client, which is not you, and the attorney, which is not you. So there's not very much that's privileged between you and the client or you and the attorney. So, but the point that when it comes to privilege is this. Let's say that you were sitting with your attorney and the client was there, and they talked strategy in front of you. Now that's privilege between them, and so you cannot disclose what happened between the client and your attorney because that's privileged, and you're not. And if they ask you that, your smart attorney will jump up there and say that's privileged because you're asking Dr. Williams to describe a conversation that was privileged information. So that's it'd be an example of what they call and say that's privileged. So if you need time to think, don't feel shy in taking a breather. For instance, a bathroom break, early lunch, or you need water. And these are legitimate reasons, right? Maybe an early lunch may not be, but need water and bathroom because you're out there, you're talking a lot and your throat will get dry, so you may need some water. So don't be shy under the deposition because it's not that formal. I mean, it's semi-formal because you have attorneys on both sides and you've got a court reporter, but it's not as formal as a court where you have a judge. And so you can say to your own attorney or the other side's attorney says, hey, can we take a break? I need to go to the restroom. So check that draft deposition document to ensure that your facts, assertions, and conclusions are correct. If you don't respond, it's assumed you accept the document it is. So again, you got usually 30 days to submit your corrections to your deposition. But if you don't, they're going to assume everything's hunky-dory and they're going to go ahead and finalize it. And then you're too late. So more general comments. Both sides experts are generally deposed. Try to get the other side's expert to be deposed first because you want to know what's your story, what's your case, and then you can huddle back after that person's deposition, and then you would be ready for your deposition, knowing where they're coming from. And just because you got deposed once doesn't mean you can't be deposed again, especially if new material has surfaced as a result of some investigations. So be prepared to also be deposed twice. I've been deposed 3 times in one case in relationship to some follow-up information. So you may be asked to help with questioning on the other side's experts, and this is under deposition. And I've done that about half to a third of the time that I've been involved. And we're deposing the other side. I've been involved as part of the questioning part. Again, you can only write it down and present it to them in real time. And sometimes during the bathroom break or during lunch that you'll discuss some of the questions that should be brought up in terms to the other side. But the better impact and to keep it fresh is to do it in real time right there, where you write it on a pad and present it to them when they're in an attorney. Sometimes if there's a deputy attorney or an attorney that's helping with them, the main attorney do the questioning, you present that information to the deputy attorney. That deputy attorney will look at it and then decide when to interject to the lead attorney to ask the question. Or he might just nod his head and says, okay, well, that's nice to know, but it's not important at this time, or that we're going to present that information later on. So the information from each side's expert's deposition is often used to determine the outcome of a trial and for the basis for a settlement. Because what they do is they look at the reports of the deposition of both sides and weigh them, and hopefully they'll make an honest, each side will make an honest assessment of the strength of their case. And then based upon, they say, you know, I'm not going to gamble on trial. I think we should cut our losses and maybe go and say, instead of asking for maybe 100,000, we'll come back and says, well, you guys, they never say this, but they're essentially saying this, you guys get a good point. How about we'll reduce our claim to 75,000? And then the other side, how about 50,000? Then they'll say, done deal. Or something of that sort. So it's a back and forth thing that are based upon the expert's deposition and the strength of the deposition, and then sometimes the ability of that experts to express those opinions in court. So one of the things that the attorneys always like to do is meet, before they commit, they like to meet you in person to make sure that you would be very good in front of a jury or a judge if that happens, if that gets to that point, because you could be the world's smartest person but not be able to utter a coherent sentence that's understandable. And for maybe you have some personal habits that are annoying that are going to manifest itself in the trial. So they'll make all those assessments to determine if we should settle or not. Again, about 90% of all cases go to either arbitration or some sort of a settlement. So if the other side's attorney asks you questions outside your area of expertise, say that you have not been asked to address these topics. So this may be an area that they know, the other side knows that that it's not your area of expertise. And so they'll try to embarrass you. See, because if you say no, that says, oh, well, look at that. This guy's not very smart. He doesn't know this question. So what you do is you just specifically state that your question that you're asking is outside my area of expertise. Another one is it's outside the area of that you were asked to address. So what I do is I just the question you're referring to is regard to topics that I have not been asked to address, so therefore I cannot answer your question. So because you were not asked to address those topics. Even though you may have an opinion on it and you know it, and they'll come back and say to you, so yeah, but it's a hydrologic question, but you have a hydrologist that's an expert, and you are a hydraulic expert. So then they'll ask you a hydrologic question. Instead of saying, oh, I don't know, you just say, I have not been asked to address those areas which are outside, the area that I've been asked to about. And it doesn't say that you don't know anything about it. No, it does say something that you know something about this, but you've not been asked it because here's an expert. Here's a case that I heard about. It was between hydrologist and hydraulic engineer. So what they did is they had a hydrologist, was a nationally known expert in it. He's just very personable and was able to express themselves very nicely. And they had a hydraulic engineer. And so the other side asked a hydrologic question. And then the hydraulic engineer, knowing that he was also a hydrologist, said, answered the question. And then they followed up saying, hey, is this a hydrologic question that we asked? And the hydrologic answer, they would say yes. And then they would go to the court and say this. This is what they did. Okay, the court would like to recognize this person as not only an expert in hydrology, in hydraulics, but also an expert in hydrology. And the other side said, sure, we'll do that. And so by law, by procedures, you're not allowed to have more than one expert in a major subject area. And by virtue of what this attorney did, he essentially prevented the hydrologic expert from testifying. And the hydraulic expert was forced to testify for hydrology as well as hydraulics. So you got to be watching out for these attorneys. They can be really sneaky. So depositions, some more suggestions. If you do not fully understand the question, ask for it to be repeated. Don't be shy about that. This is under deposition. All right. If the question is ambiguous, ask to repeat the question using different phrasing or words. So if you don't use different phrasing or words, you ask them to do different phrasing of it. So they'll do double negatives, all sorts of tricks in this questioning. And if you aren't fully understanding what their question is, tell them to use different phrasing or different words. So if the question is still ambiguous, rephrase it yourself so that you can answer it with no misinterpretation. So what you want to do, and some people don't advise against this, but I like to do this. But some experts say don't do this. But what I do is I rephrase it myself so you can understand it with no misinterpretation. So I said, counsel, are you asking this? And then they would say yes. Then it says, I will answer the question as I just phrased it. And so there should be no misinterpretation of the question and no misinterpretation of the answer. And a lot of times, when you do that, it's not exactly what they had in mind then, because they were trying to be ambiguous and you're being precise. And so then they'll say, no, that's not the question I had, and they'll do it again, and they'll try to wear you out. Use short phrases, answer directly to the questions, and do not expound or give opinions voluntarily. Don't be Gabby when you're up there doing deposition and also later in trial. So use short phrases enough to answer it adequately, directly answer to the question, and don't expand. they'll give voluntarily. So don't sit there and tell war stories or give things that are kind of a fluff stuff to add on to it, because you may bring out a point that that your side does not really want to bring out, or it's not a very good defensible point. All right, so you give your opinions when you ask for your opinions, only when directly asked to and from specific topics. Don't be evasive, but use every opportunity to make your own point across there that helps your side. But again, don't do expounding too much. Some more suggestions. If for the first time you've ever done this, practice with your attorney. In fact, I often practice. I'm an old hand at this. I've done over 40 cases. And so I still practice with my attorney. I mean, not to the detail of the deposition, but saying, okay, I'm going to talk with this, I'm going to say this. And the attorney said, what if they ask you this? And I said, well, here's how I would handle that. Critique what you will say, imagine what the other sides may ask you, and prepare a good answer to that. Prepare a good answer. Read up on the other side's expertise to anticipate their questions. And what I've done is that if I know that the other side is going to, the other side expert's going to talk about a certain topic, what I do, again, this is from their resume, I'll go into that resume and find out documents that they've expounded some experts on expertise or expert opinions on that topic, and I'll get it from the library or the internet and read up and get a good side on their area of expertise and what they're probably going to say. And hopefully I can find some contradictions, because remember, they should probably present an affidavit by this time and an expert report. Those should all be in before the actual trial, but not all before the deposition. But try to get as much of that information as possible, and that gives you an anticipation of their of the questions to you and what you can ask them during deposition. Take only the documents you'll need for the deposition. They'll enter into the court records of what you bring. What I generally do is, for accessibility, I have every document that I have on my laptop, and so I can easily access that. And then they usually have a printer where the location of the deposition is, so if they want a hard copy, you can print it out, or when you and usually all the documents that you bring into deposition is given to the other side during the discovery. So have a support document handy, an index, so you can go straight to the information without fumbling around. So now, last part is trial. So there's two types of trial: there's jury trial and bench trial. And bench trial is solely before a judge, and either side can ask for jury or the bench. And so I've been on both sides. Most of them, the three that went to jury or bench, two were jury and one was bench. Serious stuff, because usually only, again, 1 in 10 cases get to this point. Civil suits do not have to have a unanimous decision. For like California, you only need to have 9 out of 10 on your side if it's a full jury. Sometimes they'll have, I think, a 6-person jury. I'm not quite sure. But the ones that I've done in California, they always had a 12. And if it's a civil suit, not a criminal suit, only 9 out of 12 have to agree to your side. So if you have a couple holdouts, no big deal. We got at least 9, and that will be the deciding factor, the 9 out of 12. So remember that the judge and jury are not engineers, but they are not dumb too. So don't dumb down on them. You can maybe explain some technical stuff, but that's technical stuff that may be strange to almost any person, except maybe engineers or scientists. So just don't be in a condescending way that you're explaining to them, like some professors may do to their students. You're not allowed in the trial room when your case is in session. All right? You are allowed in the room when you're doing the deposition, but at actual trial, you are not allowed to. What I'm also often asked to do is be at that trial, but sitting outside to be available. So during the trial itself and the question and answering of the witnesses, and whatever, they may come back and they may ask for a recess, come on out, hunt you down and ask you some clarification of certain points, or maybe to explain some phenomenon to them so they can get an idea. And when they go back, they can continue with their questioning. So you, as an expert witness, are not allowed in the trial in your case. Now, I think there's some variations in some states where you are allowed in the trial, but you're not allowed during the portions that are related to your area of expertise. I'm not quite sure of that, but all the times I've always been told to stand outside the trial room. Trial, some more stuff. If asked an unfair, misleading question, it's perfectly correct to use your answer as an opportunity to fully explain your own position and opinions, but don't expound. That means don't go beyond the narrow area that you've been asked to address. All right, but you can use that to explain your position and opinions. If the attorney isn't satisfied with your answer, it's up to him or her to ask the question in a way that makes sense. So I've frustrated opposing attorneys before by saying that's not that's a vague question that I don't know how to answer, or that has a double negative, so I need to have it re-explained. Could you explain it and rephrase it? I'll do that when they would get frustrated, and they either withdraw the question, and then, or also what they'll do is give me a straight question. They'll rephrase it in a lot straighter way, such that I say, okay, I can understand that question, and I can truthfully and honestly answer that question. If the attorney, sometimes they'll do this. The opposing attorney tries to limit your answer to a yes and no, even though it's not a yes or no answer, but they'll try to do that. Right? And you feel an explanation is necessary. Ask, why may I explain? And that's where you explain that. And so you can sometimes say, may I explain that? And look at the judge, and the judge says, go ahead. And hopefully the judge says, go ahead before the other attorney shuts you down and says, no, you may not. Well, it's not that attorney, the attorney's duty or whatever to shut you down like that. So again, said, may I explain? So it's like this. Do you think it's possible? Do you think it's possible that a meteor can strike your levee and flood the people? And I want a yes or no answer. Well, yeah, it's a possibility. It's very remote. But it's a possibility a meteor could come out there and hit your levee during the time of flooding, whatever. So if you say yes, then the guy says, the attorney will say, well, and they use that against you further on down the case. Or they say maybe in the summation, say, well, even your expert says that's a possibility. Well, no, what we say is that, may I explain? I said, well, the chances of simultaneously meteor coming in, hitting exactly at the levee at the time is exactly when you have a flood are so minute that I can't even compute it. And so then when the guy does a summation for it, say that you admitted that the meteor could strike during the flood, then your attorney come back and says, that point that my opposing colleague made should be pointed out that Dr. Williams also made an explanation that this is so remote that he couldn't even compute it. So again, some judges will explain explanations by this, but if the judge stops you from explaining, you will have alerted your own lawyer that this is an area that needs to be followed up on cross-examination. So just because that area got shut down for some reason, like for yes or no, and you refuse to answer it, or what have you, that what they'll do is the judge may shut you down, but the opposition lawyer will say, okay, now it looks like David wanted to follow up on this area, but he was shut down. So what I want to do is I want to bring it up on cross-examination. So what they'll do is in trial, they'll ask you, and this will happen the same way in deposition, they'll ask you, your side will ask you, then their side will ask you, then your side will ask you, and they go back and forth until they just get tired of each other or tired or run out of questions. And they say, I'm finished with this witness, or this I think this witness can be excused. And then both sides have to agree to that. But during that cross, going back and forth, that's called cross-examination. Then your attorney may say, well, back to that question that the opposing attorney asked, did you have something more to add? And so by doing that, since may I explain if you get shot down, the attorney knows to come back to that topic. So some more stuff again. Dress like a professional. Don't wear a Hawaii shirt unless you are in Hawaii and a native. Don't wear a bolo tie in New Mexico unless that's your natural way to dress. Otherwise, you will appear appeasing. And sometimes your attorney will check you out. They'll say, could you put on your suit that you're going to wear or whatever you're going to wear? Take a picture and send it to me for my approval. In fact, I had a friend of mine that was an expert with this that had one of those glasses that was photosensitive. So as it would be clear under bright situation and get darker and darker, his glasses would get darker and darker as the room got brighter and brighter. Excuse me. So when it was dark, when it was dark outside, it was pretty clear. So the attorney made him get another set of glasses that didn't have that, because he did not want the light to be so bright in the courtroom that his glasses would look like sunglasses, and the attorneys, not the attorneys, but the jury would think, well, he thinks he's cool, he's wearing sunglasses. So that gives you an idea of that you got to dress like a professional and look like a professional. And I had a case in Hawaii that I thought it was nice to wear a Hawaii shirt. In fact, the opposing expert was from Hawaii, and he wore a Hawaiian shirt, but I would never do that because I'm not from Hawaii and I'm not a native there and I don't live there, so I don't want to be appeasing, so I did my regular suit. Review the other experts in your deposition just before the trial. Work with your attorney and your exhibits before the trial. Your exhibits nowadays used to be poster boards, but nowadays they're PowerPoint presentations. Sometimes you can have poster boards if you want to. It's a very important one that you want to go back to during your PowerPoint presentation, that you don't have to disrupt your PowerPoint presentation to do it. So it can maybe a site map or something of that sort. So rehearse with your attorney. If the court takes a break during your testimony, use this time to talk to your attorney about any trouble points that may have come up. Stay away from professional jargon, but if you must do it, make sure to define it. So don't make the assumption that that they understand some technical point. So you must stay, if you realize that or if you think that, what you need to do is, can I explain that word that I just stated? Like in deposition, like we went over in deposition, if you don't understand the question, ask for it to be repeated. If the question is ambiguous, ask to repeat the question using different phrasing or words. Don't you do it, ask them to. And if it's still ambiguous, rephrase it yourself so you can understand it with no misinterpretation. Again, this is the controversial part. Some lawyers don't like to see that. Use short phrases as directed to the question. Do not expound or give opinions voluntarily that you have not already expressed. Give opinions only when directly asked to and for specific topics. So same thing in deposition you do in trial. So general overall comments related to being an expert witness. I generally ask for double my usual fee for deposition and trial. Why? So what the reason is that generally, like in California, the other side pays for your deposition and your travel fees to be deposed. And so also your time that's being under oath in deposition, that opposing attorney paid for it. But some states or some amicable law firms will say, oh, we'll just pay our fee, you pay your fee. But I usually double it for deposition trial because that's one of the reasons. Because, hey, if the other side, you want to really hammer me and be nasty to me and do this, fine. Okay, it's going to cost you double. So I had one deposition I did in California. The other side was paying for it, and they deposed me for 3 days. 3 straight days, 8 hours a day. And you can imagine 8 times 3 is 24 times 2, which is double my rate, sometimes my rate at the time. I think I sent my son through college during that deposition. So usual fee is deposition. Also, if you're going to make me nervous, make me lose my hair and worry and do all that, so it's going to cost you, and that's why it's the whole fee for both deposition and trial. Have a thick skin and don't take things personally. Keep calm. You got to have a thick skin because that's their job. The other side may be likable and you may like them, but that's their job, is to get under your skin and to make you feel nervous, make you feel adequate, and sometimes belittle you. And I've had instances where the other side has tried to belittle me and to downplay my qualifications. So maintain your dignity at all times. That's what they want. They want you to get indignant. Don't get angry or indignant. So maintain your dignity at all times. So that, because you are an expert, you're a professional, and you got to maintain that professionalism. If you're being treated disrespectfully, have your attorney step in. What I do is, if I'm being treated disrespectfully, I'll take a hard look at my attorney, and the attorney will look at me and say, I'm pissed about something, and that please step in. And then the attorney will come in and do something to that effect, saying that please, my expert is being mistreated, so could you show a little bit more respect? And for instance, one law firm, one trial I was at, my side called their expert Dr. So-and-so, Dr. So-and-so, and the other side, when they deposed me, called me Mr. So-and-so, even though I had a doctorate also. And my attorney stepped up, was a very wise person, said up to the other attorney, says, Your Honor, could I direct counsel to direct my expert witness, Dr. Williams, because he does have a doctorate. And so it just shows you that they'll do any trick to try to treat you differently than their own expert. Don't argue with the other side's attorney. That's your attorney's job. So just don't get into a heated argument with the other side's attorney. And as I said before, be hard of hearing and have a weak bladder. Hard of hearing, that's where you can ask the question again, and then have a weak bladder. Darn it, that's a tough question. I have to think about it. Your Honor, could we take a restroom break? And so always do that as an expert witness. More general comments. We have about 5 minutes left in the formal presentation. So don't trust the other side's experts. Treat them with respect. Look at the jury, scan the people, or judge when answering the question, not at the questioning attorney. And this is very hard for even seasoned experts to do. When you ask a question that's you're not trying to, when you ask a question, you're not trying to convince the questioning attorney of the logic or the truth of the matter. You aren't going to change that attorney's mind. You're trying to change the jury or the judge. And so just make it a habit. Just try as hard as you can and remind yourself, when you answer a question, look at the people, that is the jury, and sometimes I'll scan the whole people, or the whole people that are in the audience too, and just to convince them. So scan the jury and look at the judge when answering the question. So what I do is I start the question with looking at the attorney, and then I'll start scanning, answering the question, looking at the jury, looking at the judge, and then go back to the attorney at the end. There's a microphone, place it so that you can sit erect while answering the questions right in front of you. Don't be a bobblehead. That looks fairly foolish. When you're sitting upright, then you bend over, hunched over to answer, and then stand up upright. Position it properly and extend it out such that all you have to do is finally turn your head to see the people. Answer in an audible and confident voice. You can't be sued for your opinions, right or wrong, but you can be sanctioned as an expert witness for criminal charges if you make false statements and forge documents, disrespect the court, not responsive to subpoenas, and so forth. So again, you cannot be sued for your opinion. You can make the opinion that I can flap my arms and fly to the moon. You can make that as a, and you cannot be sued for that if you say that's my opinion. So it's very powerful, and so that's just to protect the expert witness, that you can't be sued for your opinions, because otherwise the expert opinion, they thought that they might be sued for an answer that may or may not be proven wrong or judged to be wrong, that they'll be sued. They would not be so forthcoming in their opinions. So we're at the end of it. We've got some questions. I put my email right there in front of you, so that if you have some questions, please email me. Reference the slide number if it's appropriate on the right side. So what I'm going to do now is go to my chat session and find out if there are any questions. I'm sorry that I may have been going pretty fast, but you can see there's a lot of material to cover. I am right about 90 minutes, which is the length of my presentation. So I hope that everyone got some information out of it. Again, if you have some questions regarding this presentation, please feel free to email me. And I don't see any questions, so I will now hand it over to PDH Source, and you guys got it now. Thank you for attending. Bye.